Part 2 Lecture 4 Security and Legislation. Patrick Eustace, Ph.D. Recapping the last lesson. In Part 1 Security and Legislation, we furnished an elaborate explanation and analysis of the legal context and organizational requirements within the IT Solutions Technician Apprenticeships. Part 2 Learning Outcome. After concluding this session, participants will gain increased knowledge about the significance of organizational strategy and policy, as well as their practical implementations in the professional setting. Company policy document. The strategy should be enshrined into a company policy that details all the following. 1. Person responsible for each level of security, e.g., who manages the network security, who carries out the backups, who oversees document management, who carries out configuration management, etc. 2. Person that will carry out the necessary staff training. 3. Person that will monitor the efficiency of the policy. 4. What the agreed penalties are for breaches of security would be. 5. What the recovery system will be in the event of data loss or corruption. 6. The policy should address or outline the main points of IT legislation such as the Copyright, Designs and Patent Act, the Computer Misuse Act, the Data Protection Act, etc. ISO 27000 Series Standards. The ISO 27000 Series Standards, also known as the ISO 27000 Family of Standards, are a global framework for information security management practices. Developed by ISO and IEC, they provide a common set of guidelines for organizations worldwide. ISO/IEC 27000-2018 is a standard within the ISO 27000 series that focuses on information technology, security techniques, and information security management systems. It serves as an introduction to ISO/IEC 27001-2013 and provides an overview and vocabulary for the series. ISO/IEC 27001-2013, also called ISO 27001, is the international standard for information security. It is part of the ISO 27000 series and helps organizations establish and maintain an information security management system (ISMS) to protect their information assets and improve their security practices. The ISO 27000 series standards are designed to assist organizations in managing cyber attack risks and internal data security threats. By following these standards, companies can enhance their security measures and effectively address information security challenges. Information controls, regulations, legislations and laws. Topics to be covered: 1. Copyright, Designs and Patent Act. 2. Computer Misuse Act. 3. Data Protection Act. 4. Health and Safety at Work Act. Guidelines, Ergonomic in the Workplace. Copyright, Designs and Patents Act 1986–1998. The Copyright, Designs, and Patents Act of 1986–1998 is a law that protects the rights of intellectual property owners. Copyright covers a wide range of creative works such as literature, art, music, broadcasts, photographs, films, and computer programs. The initial ownership of copyright typically belongs to the author or creator, or the employer in the case of work created under supervision. In the UK, copyright for various works lasts for 75 years after the death of the author or creator. Written consent is required for the use and reproduction of copyrighted materials. Computer Misuse Act, 1990. The Computer Misuse Act of 1990 addresses the misuse of computers and electronic data. It recognizes the ease with which personal and company data can be communicated beyond its intended recipients. Computer misuse includes hacking, data corruption, unauthorized copying or transferring of data, software piracy, email and chat room abuses, and identity and financial frauds. Such misuse poses significant risks and costs to individuals and industries, particularly in cases of banking fraud. The Act introduced 3 new offenses: unauthorized access to computer material, unauthorized access with intent to commit further offenses, and unauthorized modification of computer data or programs. Penalties for these offenses include imprisonment and fines. However, in practice, enforcement of the Computer Misuse Act faces challenges. Many cases of computer misuse go unpunished due to the complexity and costs involved in investigating and prosecuting them, allowing individuals to evade legal consequences. Data Protection Act 1984-1998, 2000. The Data Protection Act, initially introduced in 1984 and later updated in 1998 and 2000, serves as a regulatory framework for the storage and use of personal data in computer systems. Its primary purpose is to protect individuals' privacy rights and grant them control over their personal information. Under this Act, individuals, known as data subjects, have the right to access and challenge the information stored about them. They can also seek compensation if inaccuracies in the data cause harm. Data users, entities that collect and manage personal data, are required to register their data with the Data Protection Registrar, also known as the Data Protection Commissioner. However, some specific categories of data are exempt from the Act's regulations. For instance, personal data related to family or household affairs is not subject to the Act's provisions. Similarly, company payroll data, used exclusively for wage and pension calculations and accounting purposes, is exempt. Clubs or similar organizations can hold name and address data of their members, but they must seek permission from the individuals in question. Additionally, certain types of data, such as the electoral register, which is required by law to be made public, and data necessary for national security, are also exempt from the Act. To protect personal data against unauthorized access, various measures can be implemented. These include restricting access to specific employees, implementing key-based access controls for computer rooms and terminals, assigning unique user identities and passwords, and enforcing regular password changes. The Data Protection Act is guided by 8 key principles. 1. Fair and lawful processing. Personal data must be obtained and processed in a fair and lawful manner. 2. Purpose limitation. Data should only be used or disclosed for the purposes specified during registration. 3. Data minimization. The data collected should be adequate, relevant, and not excessive for the intended purposes. 4. Accuracy. Personal data must be accurate and kept up to date. 5. Storage limitation. Data should not be retained for longer than necessary for the specified purposes. 6. Individual rights. Data subjects have the right to access their data, request corrections or alterations as needed. 7. Security. Proper security measures should be implemented to protect personal data from unauthorized access or loss. 8. International data transfers. Personal data cannot be transferred to countries without adequate legislation or regulations in place to ensure protection, like those provided by the Data Protection Act of 1998. Reflection. The Data Protection Act provides a legal framework for safeguarding personal data, ensuring transparency and accountability, and empowering individuals to have control over their own information. General Data Protection Regulation, GDPR, 2018. The General Data Protection Regulation, GDPR, was agreed upon by the EU Parliament and Council in April 2016 to regulate the protection of personal data belonging to EU citizens. It emphasizes the anonymization of collected data to safeguard privacy. The GDPR came into effect in 2018, replacing the Data Protection Directive 95/46/EC. In the context of Brexit in 2020, the UK revised the EU GDPR regulations to encompass all aspects of its original Data Protection Act, including privacy regulations. One of the fundamental principles of the GDPR is the principle of integrity and confidentiality, or the security principle. It mandates that data controllers and processors implement appropriate security measures to prevent accidental or deliberate compromise of data. According to Article 4 of the EU GDPR, a data controller is the entity that determines the purpose and means of processing personal data, while a data processor is the entity that carries out the data processing on behalf of the controller. The UK GDPR establishes 7 key principles. 1. Lawfulness, fairness, and transparency. 2. Purpose limitation. 3. Data minimization. 4. Accuracy. 5. Storage limitation. 6. Integrity and confidentiality, security. 7. Accountability. These principles ensure that personal data is processed legally and ethically, with limited data collection, accurate and secure storage, and transparency in data handling practices. Organizations are held accountable for complying with these principles and are required to implement appropriate measures to protect personal data and maintain its integrity and confidentiality. That's it for now, folks. Thanks for watching, and see you in part 3. Goodbye.